Okay, good morning and welcome to our second session with us on ESELA for this year. We have Susan Geary here from Bricker and Eckler to speak to you on IEPs today. If you have any questions, please put them in the chat box, and either Aaron, Greg, Kim, or myself, one of us from state support team, will make sure we get those questions to Susan for answering. If you are in need of ASL interpretation services, please pin the person to the top of your, if you go to the participant list and click on the down caret when you highlight their name and it says more, if you hit pin, that way that person will always be on the center of your screen. That would be great. We also have turned on live transcript for those of you that might need that accommodation as well. If you have any trouble with accessing those things, please send me a direct message in the chat box and we will make sure to get you connected. It's all yours, Susan.
Thank you. Our session today is on IEPs, and you should have a handout from me. I am going to speak from the handout, so if you want to follow along in that, that has more information than on the PowerPoint slides. We'll use PowerPoint slides, but you also should have a copy of those, I believe, at the end of the handout. And then finally, you should have received a copy of a blank IEP form. I am going to refer to the form, so you may want to have access to that while I'm speaking. As Steve mentioned, I welcome questions. I would rather have questions from you than to talk about what I have prepared. So please ask them, submit them in the chat, and then Steve or someone else from the SST is going to read them to me, and then I can address them. I'll take a break at around 10:15, 10:30. This session is from 9 to about 11:30. And I think with that, we will go ahead and get started. Again, I'm going to present from the handout, so if you want to follow along in that, excuse me. We have themes that are part of the IEP, and in fact, the whole IEP process that we used. One is instruction based on scientific research-based intervention and peer-reviewed research. And you see that a lot now with reading, with different programs and reading systems and also math, but really everything we deal with in special ed. Behavior is another example. So instructional programs and instruction that is research-based and picking systems that are beneficial to individual students based on their disabilities and needs, strengths, and weaknesses. Reading. Reading is Maya, we're on the prior slide. Oh wait, never mind. I made an error there. That's correct, we're on themes. Another theme is reading, which is huge now, as all of you know, with the dyslexia requirements that are coming into play that have already started as far as training for staff, and we're delayed a year to start next year for students with screening. And then participation in the regular education curriculum and least restrictive environment for students. So a focus on LRE and students participating in the regular curriculum to the extent that is appropriate for the individual student. And then of course, transition to post-secondary for students so they're prepared for work, further education, whatever they're interested in or may be appropriate for them. And if you think about the IEP and what we need to do with education and IEP goals and objectives, that's the focus. And so there are definite themes throughout the entire IDA, with the end goal really being transition of students to post-school and being successful. Definitions. One definition that you need to think about as far as who gives consent, who's invited to meetings, a variety of items with the student, are the definition of a parent. Who is a parent? Who can consent to initiation of an IEP, who consent to an evaluation. And it's a hierarchy. So you start with the biological or adoptive parent, or it can be, but it's not a foster parent. So the first thing that you look to is a biological or adoptive parent. But if they're not in the picture, not available, and you don't have a biological or adoptive parent that has custody of the child, then you look to others who can function as a parent. And note that a foster parent is not included in that, a foster parent is prohibited by Ohio law from serving as a parent, like equal to a biological parent, and is not considered a parent. Now, they could be appointed as a surrogate parent, and we'll get to that in a moment, but they are not just equal to a biological or adoptive parent. But a biological or adoptive parent may not be in the picture or may not have custody of the child. So we also can look to a person who is acting in the place of a parent, and that could be someone with whom the child lives, such as maybe a grandparent, an aunt, someone like that. So we can have a person who is not a biological parent, but is acting as a parent, and they don't have to have custody, but the child may be living with them. And so they also can function as a parent. As I noted, a foster parent can be a surrogate parent if appointed by a court, which rarely happens, or appointed by the school district of residence. And then, and the surrogate parent, they have to take the training, and note that the training changed recently. So they have to have the current training from the SST, and they do have to be appointed. Someone can't just say, I want to be the surrogate parent and I'm going to be that. It is up to the district of residence who they appoint as a surrogate parent. And it does not include a guardian ad litem, which once in a while you may have in the picture with a student. A guardian ad litem is appointed by the court to represent the child in court and is not a surrogate parent unless the court has appointed them as that, or the school district of residence has appointed them and they have taken their training and meet the qualifications. The proposed operating standards are going to be revised, the special education operating standards. They are going through the process right now and are at JCAR, the Joint Agency on Rule Review. And so after they have passed that agency, they go back to the State Board of Education, the full board, for a 119 hearing, which is a public hearing. And if the board approves them, the State Board of Education, then we will have new operating standards, and that could happen during the school year. Hopefully, ODE will not have the regulations go into effect once they are amended during the school year, but we'll wait till summer. But in any event, if they start to use the new operating standards, it'll probably be more of a soft roll-in, which they have done in the past, and then to be fully implemented during next school year, assuming that they pass the state board this year. And there aren't a lot of significant changes in the proposed new special education regulations. There are a lot that you might see in the area of IEPs and that regulation. But if you look closely, a lot of those IEP changes are changing, for example, using the initials IEP and striking that out and writing in the full individualized educational plan, but not a lot of significant changes that you'll really see across all of the regulations, but including in the IEP session. But there are changes with surrogate parents, as you'll see at the bottom of page 1. There's a footnote there that talks about that. And then over on page 2 of my handout, just note, if parents have joint legal custody of a student, only one of those parents has to consent to to special education steps where a parent is required to give consent, like an initial evaluation, reevaluation for new evaluation that is being done as part of a reeval, or for an initial IEP, for example. And I think I will stop here and take any questions because a lot of times there are some questions about who can function as a parent at an IEP meeting, an ETR, or giving consent. So Steve, any questions that we have?
No, there's no questions in the handout or in the chat box so far.
Okay, we'll move on then. If you think of some questions later, feel free to ask them.
Yeah, some people are asking about the handouts, sending me like direct messages about the handouts. The handouts are in the in the folder, and I'll paste the link in there for you. The slides are at the end of that handout.
Steve, I put the handout link in the chat.
Okay. Yeah, I just threw it in there again. Thanks, Greg.
Yeah, thank you. Yes, I am speaking from my handout, so that will be helpful. If I think that you should have received it before today, so it should also be wherever you received the invitation and the link. And you should also have a blank copy of the IEP form that you can refer to if you would like to. Okay, I'm on page 2 of the handout at the top. Initial evaluations and reeval as it relates to the IEP process. I know that you had a first session where you talked about evaluation, but I wanted to focus and reinforce that with an evaluation, especially an initial, but also reeval, we are not looking so much anymore at just on eligibility. Yes, you do need to determine the eligibility of the student and what category of eligibility they meet, like SLD, cognitively, disability, whatever that may be. But you aren't just looking at eligibility. A focus of the evaluations that you do is on gathering information that you can use for an appropriate program for the student and developing the IEP. And at least when you first do the initial eval or reeval, when the data is fresh and current, using that as a baseline for your goals and objectives. So whenever I'm looking at an IEP, what I typically look at is I would start and look at the evaluation. And what does the current evaluation say about the needs of the student? Excuse me, I have some allergies, so take a drink.
Hey, Susan, we have a question too.
Okay, yeah, let me just finish this one part and then I'll pick up any questions, including from anything I've talked about so far, but thank you.
All right, you let me know.
Okay, yeah, I'll cue questions when I get to them. Thank you. So there should be a link from the evaluation looking at strengths and weaknesses, looking at what are the needs of the child. And sometimes you have to prioritize those because you can't meet all the needs at one time in an IEP because it would be too much, or maybe a student needs a certain skill before they can move on to work on something that comes after that. And so I would look at the evaluation, look at what does the child need to have on their IEP. And then I would look, and we'll talk more about this part of IEPs later, but I would look to the present level and see that there's a baseline there that you can determine if the child's making progress. And then look at the quantitative baseline and move to the goals and objectives and say, is this linked to the present level of performance, which is in turn linked to the evaluation data and the needs of the child. So it is important that the evaluations be well done and that people don't forget about them in developing the IEP. But the evaluation so determines if the child has a disability, what is the category of disability, determines present level performance and educational needs, and then determines does a child need special education and related services. And you might think, well, they're always going to need special ed and related services. And 99% of the time, yes, if they qualify, they will need an IEP. But it's theoretically possible for a child to qualify as having a disability, but not need any services. It rarely happens, but that can happen, but they would still be eligible under the IDEA and identified as disabled. Okay, Steve, I'll stop there for a moment. You said there were some questions.
Yeah, there's one. It says, so if a foster parent attends the IEP and signs off as the parent, who should have done this instead of the foster parent?
Okay, a foster parent, first of all, can attend an IEP meeting regardless of whether they have been appointed as a surrogate parent. So if the surrogate parent or the district invites the foster parent, they can attend. And many districts do that because that can be very appropriate and helpful for the child in the school because that's who the child is living with. But in order to function as the parent at the IEP meeting and give consent and sign as the parent, typically the district of residence is going to need to appoint a surrogate parent unless in the court order that removed custody, the biological parent still retains the right to make educational decisions, or children's services, if they have custody, is saying the biological parent still retains the right to make educational decisions. But typically it's going to be a surrogate parent. It is not the foster parent unless they are appointed as the surrogate parent. And when you say they came and they signed, whoever's in charge of the meeting should be paying attention to that and should make sure if the foster parent is not the surrogate parent, that they don't sign in the wrong place. And if it happens and someone then notices, it needs to be crossed out and corrected on that, because whoever functions as the parent at the meeting is the person who signs in the line for parent. The foster parent can sign as a participant, but doesn't sign as a parent or sign the last page where the parent signs off. Any other questions? Okay, hearing none, we'll move on. I'm on page 2 in the middle, summary of primary steps in the IEP process. These are the steps that we're going to talk about today. And this is basically, these are the major steps in the IEP that are on the form. And I'm going to go somewhat in order of the form, but I also have rearranged a couple of things like looking at ESY and some things like that in just an area. To me, it made more sense in presentation. But generally, this is the order in the IEP. And in your initial IEP or annual review, you need to go lockstep through the areas that are in the IEP form. So for example, you need to do the profile, the goals and objectives, and then section 7 with services before you get to least restrictive environment. And it can be a legal problem if you just move, for example, to least restrictive environment without doing those other preceding steps, because you might be seen to have done predetermination of the placement, with the premise being, how do you know what the least restrictive environment is until you have developed the goals and objectives and determined the services needed, because only then can you look at where those services are available and the needs of the child can be met. So make sure to go in lockstep through the steps. And sometimes parents don't want to do that. They may be only interested in the least restrictive environment. You know, where are you going to place my child? Are you going to place them in a private school I requested? Are you going to have them attend in the district in a school? But you just have to stop them and say, we have to go through these earlier steps in the IEP first, And then we will get to LRE at the end, because as I said, it can cause you a problem with predetermination if you don't go through it that way. Now, if you have additional IEP meetings in between the annual reviews, and you're having that for a limited, more narrow purpose, for example, maybe you need to change goals and objectives on occupational therapy. But that's all you need to do at a meeting between the annual review meetings, then that's okay. You can just have an IEP meeting and focus on what you need to focus on. But annual review, you need to go the whole way through the IEP step by step. Content. And I'm moving to slide 2. We'll talk about the different steps of the IEP. Future planning, which is in the IEP. This is not a federal requirement. This is an Ohio operating standards regulatory requirement. And it does, the future planning is really up to the parent. And it's what the parent is interested in the child's future. Are they thinking that they may go to college, or they're going to get a job when they have finished with secondary school? And this is not subject to due process. So the parents can really indicate, and the student, once they are older in high school, for example, what they want to do. And sometimes parents are not realistic about this, but it's what their dream is for their child, what they want for their child's future. And it is pretty much, you can include what the parent is requesting there, and it changes over time. You know, the future planning can look very different for a student in kindergarten versus a student who is in high school, where you're, you know, looking to post-secondary transition. The profile. The profile is also not a requirement from federal law. It is an Ohio requirement. And what it is supposed to be is really just a quick summary of the strengths, weaknesses, needs of the child, and has some basic information, maybe like state test scores, things like that, and, you know, major needs. Now, what I see a lot in the profile is that people regurgitate everything that is in the current evaluation, or maybe some updated evaluation information if you're between 3-year evaluations or reevals. But that's really not what you are required to do. It is really a summary to give the big picture of a child. Now, sometimes parents and attorneys for parents or advocates, I'm not sure why, because you have the evaluation information that is also in the child's file. So you're supposed to be knowledgeable about that and referencing it, but you don't have to regurgitate all of it into the profile. Now, often a parent or their representative will want that. There's no prohibition on that, how much you put in a profile, but it is really supposed to be an overall summary. The more granular information, the more detailed, should be in the present level of performance related to a goal, because that's where you're putting where a child is functioning at the time you are developing the IEP. So instead of putting it all in a profile and then again regurgitating it in the present level, you have your evaluation document, and then just do an overall summary of that and other basic information in the profile. But sometimes parents want that, no prohibition on it, and it's often not worth having a dispute about that. You can just put it in if you choose to do that. Okay, over on page 3, and I think I'll go through annual goals, and then I'll take some questions after that. Present level of performance in the IEP on the goal pages. It's really important that you have quantitative data, baseline data, written into the present level of performance for each goal as to where the child is functioning at that time, related specifically to the goal that you are putting in the IEP. And so the goals should reflect how the child's disability affects their involvement and progress in the general curriculum. So there should be some information in the present level of performance about that. But the key is quantitative baseline data, which needs to be there. And a lot of times I don't see data that's based on, what has been collected about the child that you can use to determine progress when you're looking at the goal. And then, of course, measurable annual goals. They do need to be measurable. Now, you can also have benchmarks instead of a goal. And a benchmark is based on a timeline, and you might have down in the objectives, you might have what a child's expected to achieve by, for example, November, and then what they're to have achieved by January, and then maybe March, and then maybe May. So benchmarks are marked by time periods, but more typically we see annual goals, which is what is to be reasonable for the child to achieve within a year, so within the IEP period, which is typically, a year, but can be less time than that if the IEP team determines that's appropriate. And goals need to include what are you expecting the child to do? Will do what? And under what conditions? And then performance criteria so that you can measure progress, which is key. In special education, a key issue is measuring progress, because that's what we're looking for, that the child is progressing from year to year in their goals in the areas of need for them. And an example of a goal might be, and just when presented with a list of CVC words, so consonant, vowel, consonant, Eric will correctly read the words out loud with 80% accuracy in 4 of 5 trials. So they should do what? They should be able to read CVC words correctly out loud. So we're saying the conditions, and then we're saying the performance criteria, which 80% accuracy with 4 out of 5 trials. And that's not in your handout. That's just an example of a goal that you might have. And then the objectives would relate to that, leading up to being able to achieve the goal annually within the IEP period. So before we go on to special instructional factors, any questions, Steve?
Yeah, there's one question. Is the profile subject to due process?
Profile, yes. The future planning is not. Excuse me. Okay, I think I'm good.
Yeah, that's all we got right now.
Oh, okay, thank you. Sorry, I'm coughing. The special instructional factors on page 3 of the handout. The IEP, these are things that are to be addressed in the IEP if they are applicable to a parent. The IEP team, in the case of a child whose behavior impairs their learning or that of others. And Maya, I think I'm on the prior slide there. I think you need to go, okay, go back to the one that you just had. Yes, leave it there for a moment. Okay. The IEP team, in the case of a child whose behavior impedes his or the learning of others, is to consider what needs to be done to address that as part of the IEP. And so you might have a goal and objective on the IEP. You might have a behavior plan after you have done a functional behavior assessment. So there can be a variety, you might have accommodations. So there can be a variety of items on the IEP that can be used to address behavior. And that will vary from child to child, depending on the severity of their behavior and what is appropriate for them. Another instance might be if you have a child that has had discipline issues, so you have suspended, or you're looking at whether you will suspend or expel the child. If it's determined in the manifestation that there will be no suspension or expulsion because what they did to violate the code of conduct is found to be related to their behavior, to their disability, excuse me, then you would need to conduct a functional behavior assessment, and then most of the time you're developing a behavior plan. So that's another example. And that would probably have some reference in an IEP because you have a student that has a lot of behavior concerns. And so you have a behavior plan that needs to address that. And it's not looking at the behaviors part of the IEP is not limited to just students who are identified as emotionally disturbed or ED. It can be any child with a disability. So it can be somebody who is identified with a speech disability, but they also have behavior problems. So that may need to be addressed in the IEP. And ODE has an optional form for a functional behavior assessment and an optional form for a behavior intervention plan. A district can have their own forms for that because they are optional forms from ODE, but you can use those if you wish to. Then also for a child with limited English proficiency, the IEP team needs to consider the language needs of the child as it relates to the IEP. Now, you're not just writing information about what happens in English as a second language, for example, and working with the English as a second language teacher. It is not a plan for English as a second language, but what you need to put in the IEP is information or goals and objectives or information that relates to implementation of the IEP. So for example, you might need to have in the IEP that the English as a second language teacher will work with the intervention specialist and cooperate with them on certain sorts of information you're providing to a child, or the English as a second language teacher may give some tips to the IS as to what would work well for this child to be able to work on their goals and objectives and learn from the curriculum. So a cooperation example. And then for a child who is blind or visually impaired, the IEP team needs to look at, are there considerations related to Braille instruction, for example, for a child who is blind? And there is a page that's part of the IEP that is only used, it's section 16 on an IEP, for children with visual impairments. You don't need to use that page unless you have a child with a visual impairment. And then you have to fill out that page as appropriate to the child. And one thing I want to mention with children with visual impairments, it depends how severe their impairment is. What is the prognosis for that? And does the child need to learn to use Braille? And I see some IEPs where a child may be able to see somewhat, especially using technology, may be able to read at the current time, but the prognosis for their vision might be that it's projected to deteriorate. So don't forget about Braille. and don't just rely on technology. It may be appropriate for a child, in addition to using technology to assist them with their vision or with blindness, they may need to learn to use Braille, because just like we all use technology, we're using it right now, but we have learned to read, visually, unless we have a visual impairment that we need to use Braille, for example. But for a child with a visual impairment that's severe, may deteriorate, they may need to use Braille as like basic reading to them, because we're in situations where most of the time we could use technology if we had to be able to read, even if we don't have a visual impairment. But sometimes you're in a situation where you don't have tech with you, or there's an emergency, you don't have it or you've lost it. Well, similarly, if it's appropriate, a student with a visual impairment may need to learn Braille. So just don't forget about that when you're reviewing the IEP and determining if it's appropriate. Communication needs of the child at the bottom of the page. The IEP team is to consider the communication needs. Now, note the language of the child. So kids learn a basic communication method. And then when they may move from school to school, for example, district to district, they need to learn their communication mode that they are learning. So, and not just switch because of the program that a district happens to have. So that may mean that if your district does not have a particular program that they teach, like signing, cued speech, a program for a student with a cochlear implant, for example, then a district may need to send a child to a program that is appropriate to them in their mode of communication, in their language and communication need. So you may, for students with hearing impairments, you may need to have access and know where you can find different sorts of programs to assist with that based on what the child's mode of communication is. And so, as I said, you need to be sure that you can offer a program like that, not only if not in your district, in another district or program that offers a different mode of communication.
Hey, Susan, we do have a couple questions when you get a chance.
Okay, I was actually going to stop right now. So this is a good time for questions.
The first one is, if you have a behavior goal for the student in the IEP, do you need to mark the first question in section 2 as yes? So they're talking about the special instructional factors.
Well, I would think if you have a behavior goal, now, sometimes it depends on what you mean by behavior. If you just have a child who maybe they resist doing work, and so you need to have a behavior plan so they are motivated to stay on task and do their work. It depends how, in my view, it depends on how severe that problem is. If the behavior is significant about the child being able to stay on task and do work, and do they act out when they're asked to do some work, then yes, you might say that the child has a behavior concern. On the other hand, if it's maybe not that severe, but it's something you have to work on with the child, it may not be appropriate to put there. Now, a lot of times people think a behavior just is acting out, or behaviors that we don't want a child to be doing, but it really can mean a lot of things. And so it's up to the IEP team. And I think mainly so the parent and the rest of the IEP team know what that means. But if a child is having significant behaviors that are causing a problem, like we would typically think of, bad behaviors or behaviors that we don't want to see, then yes, that would typically be checked, but it's up to the IEP team. Okay, other questions?
Okay, and just to follow up on that, the direct guidance from ODE has been that if that box is checked, then it needs to be addressed somewhere in the IEP. They're not saying it must be a goal or it must be a behavior plan. Just if it's checked as a concern of the team, they need to address it somewhere, accommodations or whatever it may be. That's kind
Yes,
of left up to the
that's
discretion of the team.
That's correct. And it might just be an accommodation. That may be a way to address it. So for example, if a child has acting out when they're transitioning from class to class, maybe the accommodation is just you let them leave earlier or later to transition to another class so that they don't encounter all the other students in the hallway. And if that addresses the behavior and all you need is that accommodation, then that's addressing the behavior if that's appropriate and sufficient for that child. So yes, exactly. It just needs to be addressed somewhere in the IEP as appropriate for that child. Other questions?
Yeah, Judy asked, could you please clarify section 4, extended school year services? And then it says the consideration in determining the date of review. When, Judy, you might want to come on and just clarify what you're asking to make sure that.
Well, let me interject first. I will get to ESY. So let's wait until we get to that in a little bit later in the presentation. And then if you have a question, we'll address it. I'm not sure what you mean by the date though.
There's a date on there as when the team will reconvene to discuss ESY services. I think that's what you mean.
If you're talking about, is that the question?
That's on ESY in section 4. There's like a date section.
Yeah, yes.
When the team will reconvene. I think that's what the question is.
Okay, we'll get to that when we get to ESY, and that'll be in a little bit. And then if you still have a question, please ask. You know, I had mentioned that I'm taking a few things out of sequence in the IEP, and that's one of them. So
there's a question. If you have a goal with objectives, do you have to progress monitor the objectives from the start, or can you progress monitor them as the student achieves them?
I think in a progress report, and there is a form from ODE, or a district can have their own form, that you probably need to somewhere have them noted on the form. So you're looking at what the goal is and then what the objectives are. And if you haven't gotten to a particular objective, that's what can be noted is, you know, not implemented yet or not started. Just be sure that you're indicating progress on what you are working on. So it depends on the nature of the objective, whether you need to be working on them or whether they're sequenced and they need to work on a preliminary one first. Other questions?
Yeah, I'm just trying to sift through them. If you have a behavior goal for the student in the IEP, or no, I already read that one. I'm sorry. If there's a behavior goal, does there have to be a behavior intervention plan?
Not necessarily, because it depends on the child, how severe the behavior is, and what makes sense in terms of working on that with the child. So you may have just a goal. And again, it depends what the behavior is and what you're trying to address. So some students may have only a goal to address a behavior. Some students may have only a behavior plan with addressing the behavior, and others may have both. So it really differs from student to student. Other questions?
Yeah. Is severity the determining factor in deciding between a behavior goal on the IEP and a behavior plan?
Not just severity. It depends on the nature of what you need to work on. And an example might be if the behavior you're trying to address is you maybe want the child to work on a task and, you know, stay task oriented and improving their on task time from maybe a minute to 2 minutes or whatever timeline you're doing, that might be appropriate for a goal. And that can be a behavior issue depending on the reaction of the child and why they're not wanting to work on their work and be on task, and how they react to saying, I don't want to do this work anymore. That might be appropriate to have a goal. On the other hand, if they really have a severe reaction when they're asked to do certain work, that might be appropriate for a behavior plan. So it really depends on the child. You just have to be able to show and have data to show that it's appropriate, that you are addressing that behavior, whether it's an acting out behavior or some other behavior that you need to address. And it could be increasing positive behaviors. It's not just reducing negative ones. So any other questions?
Is it appropriate for a behavior intervention plan to focus on several areas of focus, or should it solely be focused on one specific behavior?
A behavior plan can focus on more than one behavior. It's just you need to, thoroughly address each behavior then, just like you could have 2 goals related to behavior instead of just one. So whatever the child needs and is appropriate for them, you need to address, because you could have a child who has significant behavior problems. Maybe they don't have any academic problems. So their IEP might be focusing mainly on behavior and not including a lot of academic goals and objectives. So it always goes back to the individual child and what is appropriate for them. Okay, other questions?
That's all I'm seeing right now.
Okay, let's look at page 4 on the handout. And Maya, that's still the same slide. This one stays up for a while. Transition from school age to post-school. You begin at age 14, of course, and this is a focus that ODE as well as the U.S. Department of Ed looks at, because that's what we want. The end goal is for a student to have a successful transition to whatever they're going to do post-secondary, which may be a job, it may be further education, but to make that successful for them. And we have to have measurable post-secondary goals that are on the IEP, and there are several sections of that. It's in section 5, post-secondary transition in the IEP form. And you're supposed to write post-secondary goals in areas, post-secondary training and education. There is an employment area and independent living where it's appropriate for a student. And so for each of those areas as appropriate, you need to have a goal. And an example might be, John will attend a 2-year community college and obtain a degree in culinary arts, something like that. And then you need to talk about in the goal and describe, what training and education they need to get ready for that. What courses do they need to take? What sort of education while they're in, secondary school, what courses of study will they take? And then what transition services or activities will they need to address that goal? And notice it's activities. And so it might be to identify 2-year colleges that offer culinary arts. That might be an activity that's appropriate for a student who's interested in that. It might be to use the K-12 backpack to explore culinary arts and what sorts of jobs are available in that. Maybe a chef, there may be other areas like a, nutritionist or something. So it's whatever that activity is appropriate for them. And then the type of evidence indicating, and note, it's that the service has been completed. that the child has completed that activity. You're not measuring the progress like you do in a goal, but you have to indicate that the service or activity under that post-secondary goal has been completed. And then you fill out a form to indicate when it's been completed and has it been, or where are you in working on that. And that's a form that is similar to a progress form. And there's an optional form from ODE. A district can use their own, but it has to be completed. And that's on the schedule in the IEP, like measuring progress on other goals in the IEP is. But note that it's progress on goals and objectives versus here it's looking at has the activity or service for the student been completed. Okay, I'm going back to just the goal page for a moment. You have to also, and this is G in the handout, measure the child's progress toward the annual goal. So we've left transition. We're moving to annual goals and objectives again. You have to do progress reports and they have to be done on the schedule identified in the IEP, which is often every 9 weeks, when report cards are issued. It may be less than that. Sometimes we have every 5 weeks. Once in a while, maybe we have every other week. So it depends on the needs of the child and measuring progress for them, but it has to be at least as often as report cards are provided. Or if there are interim reports provided for all students, then at the same time, you would also have to provide a progress report for a student with a disability on their goals and objectives. But for example, if you only issue progress reports, interim reports to students who are failing a class, for all students, including regular ed and special ed, then you only need to do a progress report for somebody who's not making progress, essentially, not doing well and passing on their goal and objective, so to speak. So any other questions before we move on to section 7? Which is specially designed services, related services?
No, there's no other questions right now.
Okay, if you look, I'm so sorry, I'm clearing my throat so much. On page 4H, this is section 7 in the IEP, the specially designed services and related services and accommodations and modifications. So in the sections on specially designed and services and related services, note that you include on section 7, what is the specially designed instruction? What is the goal that's addressed by number? So you're indicating what goal is being addressed in the specially designed instruction. Who is going to provide that? Is it the IS, the intervention specialist? And what location? Is that going to take place in a resource room? Is it going to take place in a small group in a regular classroom? And then when are you beginning that specially designed instruction for that particular goal? And when does it end? Which typically will be the same as the beginning and the end of the IEP, but can differ because sometimes you have added a new area for specially designed instruction in between annual reviews. And so you may have a different start date for that. Maybe it's something that's only going to last a certain period of time. So you may have an earlier ending date, but typically it's going to match the beginning and ending of the IEP itself. Amount of time. You need to put the amount of time and the frequency. So, 30 minutes a day for 4 days a week or something. So you need to indicate how much time, and that needs to be specific. You can't do a range like, from 30 minutes to 60 per week. It can't be a range. It needs to be specific, and you need to indicate how often that's going to happen. Once a week, 4 times a week, whatever it may be. And then with related services, same thing, but it is for the particular related service, and you need to list each one, just like you need to list the specially designed instruction for each goal. And then on section 7, also assistive technology. What assistive technology does the child need? And any instruction in that, beginning and ending, when, amount of time, that is there also. Now, accommodations, what accommodations does the child require? And then modifications is not just an accommodation of the regular curriculum, but it's modifying the content of the curriculum as appropriate to a child. So a child who may be taking the alternate assessment, for example. Support for school personnel, that is typically where you would write aid services, AIDE, person, and whatever the aid services may be, classroom or one-on-one. But that is typically, now this is just what ODE decides, and I'm not sure why it goes there, but it typically would. So support for school personnel, and then services to support medical needs, which may be that something needs to be provided through the school nurse, or something needs to be provided from an aide for a student. So a variety of things that can go there. Maybe the services to support medical needs is to assist the student in checking their levels for diabetes, for example. So whatever they may need. And it may reference some sort of healthcare plan that you have for the child, or a safety plan there. And before I go on to the next area with least restrictive environment, any questions about section 7?
There's not one about section 7 necessarily, but there's one.
Yeah, anything is fine. That's okay.
I'm just trying to clarify progress monitoring. If a student with an IEP is receiving an interim due to not meeting expectations in a class or classes, do they also need to send progress reports at that time?
That's what I try and look at, is what are we doing for regular education students, and then doing something similar as far as progress reports. So we at least need to send progress reports on the goals and objectives when report cards are issued. So that's typically every 9 weeks. If regular ed students, all students, I would say, including students with disabilities, receive interim reports, just regular interim reports. If everybody receives one, no matter whether they're doing well or they are not doing well, then students with disabilities should also get a progress report at those interim report timelines. But if a district, for example, only gives interim reports to students who are not doing well in school, then I would equate it to then only students with disabilities who are not making adequate or expected progress in goals and objectives on the IEP would receive a progress report at the interim report period. So I try and equate it to what regular ed students receive, but it has to be at least when report cards are provided. So any other questions?
Yeah, 2 more. Can you talk about service delivery? Can instructional assistants be listed on the IEP as the people who deliver the service?
I just want to clarify, whoever asked the question, do you mean that an instructional aide can be written down as the service provider?
Yes.
Okay. Typically what you're talking about there is a person who is delivering instruction, and it is a teacher who is to be delivering the instruction for the child. The aide is supporting that. which means that they are able to work with a child, one-on-one, working on something, but they're not in charge of the instruction. So it typically would be the teacher who is providing the instruction. It is an aide who is supporting that. So other questions?
Yeah, is it possible to have related services only in section 7 without specially designed instruction?
Yes, it doesn't happen a lot, but of course with speech and language, where you have a speech and language personnel delivering those services, that's written into the regulation specifically. If all a child needs is speech and language, then that becomes their service, their IEP. And you might not have any other goals and objectives. But similarly, it doesn't happen as often, but it's possible for a child to need another related service like maybe OT or PT, but they don't need anything else. They might be a child that has an orthopedic disability, but that's all they have. So they just need maybe a PT or an OT to work with them. And then that would be all that is in the IEP and on section 7. And it becomes like speech. It becomes the service that they receive. That does not happen often, but it can. Okay, other questions?
Somebody asked, what about only occupational therapy?
I think I just answered that.
Yeah.
So yeah, you can have that.
And then can you please confirm that programs such as communication learning system, such as LAMP? I'm not understanding this question. Kim, if you want to come on and kind of clarify.
Good morning, everybody. Yes, I have some speech and language pathologists that are kind of adamant about adding the specific language and program that they're using in their SDI. And they want to specifically put in LAMP, which is a communication language learning system. And we've been instructed through our SST to put in language that is not so specific, more, I don't want to say generic, but I'll use the word generic for lack of better words at the moment, such as a communication learning system, and not specify LAMP. Can you talk to that at all?
Yes, that would be, talking about methodology, and it's up to the IEP team. First of all, the IEP team decides. It's not just one member of the IEP team, like the speech and language provider, but the IEP team decides what is written into the IEP. And typically, a district does not want to put a methodology written into the IEP and isn't required to unless it is the only methodology by which a child can make progress and get benefit from. So if that would be, so for example, I don't even know what the LAMP program is, but if the LAMP program would be the only program, only methodology that child can make progress using, then it may be appropriate to write that into the IEP. Although typically it would, even if it's a program the child's been using, typically it would, a methodology is not the only methodology that can be used for the child to make progress. So just like we have in reading, you usually don't see a specific reading program written into an IEP like Orton-Gillingham or Wilson. You typically would see just a more generic, like you said, descriptor of what the methodology or program uses as, part of their program, but there could be others that meet that. So, and reading is an easier example. I think you might have something in reading that says, that the child is using not a particular program, but, what the reading program does, but it could describe, for example, Wilson or Orton-Gillingham or some other sort of program. So does that answer the question? Okay. I will just assume that it does, since I don't hear a follow-up.
Yeah, we get that question a lot with like you said, the Orton Gillingham, the multi-sensory approach. So we've always encouraged the districts to speak more to what that program does for the student as far as the skills it helps and reinforces, as opposed to like the name brand of it. Because if they switch schools and that school doesn't have, let's say, Orton Gillingham, but they have other multi-sensory approaches to teaching reading and literacy, then it's more about the skill and the support as opposed to what the generic name of it is.
Yes, exactly. So thank you, Steve. That was actually more articulate. So I appreciated that. A better way
We get
than
that question a lot, so I've rehearsed multiple times.
I'm sure you do.
But
Other
no,
questions?
that's it. That looks like all the questions right now.
Okay, let's move to least restrictive environment, which is section 11 of the IEP form. And this is on my handout, page 4I. To the maximum extent appropriate, children with disabilities are to be educated with children who are not disabled. So it's a continuum of services. And you do start out saying, that you're making the initial assumption and the starting point that the child will be educated in the regular education classroom. And then you say, is this appropriate for the child? And if it is, that is the placement. But if the child needs another sort of placement or environment in order to implement their IEP and be able to be successful and make progress, then you go from the least restrictive, which would be regular ed, to more restrictive placements, asking the same question. If regular ed is not successful, what about, pull out of that regular ed situation for part of the time? So maybe you have some pull out to a resource room. If being in the regular school district placement in the school where the child lives and would normally attend, if that's not appropriate, maybe a child needs to go to a specialized program outside of the school district. Maybe that's not sufficient for a few students. Maybe they need to go to a residential setting. So you go from least restrictive, asking the question, is this appropriate and meets the child needs, to more restrictive. And obviously it's not always looking at the whole day. So a child may be pulled out to a resource room, for example, for a particular instruction or subject areas or assistance, but not spend the whole day there. So most students are in regular education for, either part or all of the day, and that is appropriate for them. But we have a few students who need more restrictive settings and, may not be in regular ed much or maybe at all if, for example, they require a separate facility setting to meet their needs. And on section 11, it asks questions. The first question is, does a child attend the school where they would attend if not disabled? And if the answer to that is yes, then you just check that. But if it's no, you say why. Maybe a child needs assistance in a program for students with visual impairments. Maybe only one elementary school in your district has that program. So they may need to go to another elementary school in your district other than the one that they would normally attend, or has teachers who have special training in behavior management. Maybe that student needs to go to a different school within your district to be able to receive those services. And then it also asks, does this child receive all education services with non-disabled peers? And only if they are in the regular education setting where they receive their special ed services would you check yes. Otherwise, you would check no for that. And then there's also a section on preschool there that is similar. So I'm going to move on to, one thing I wanted to mention on LRE. I noticed this on a lot of IEPs, that it's difficult when I look at some IEPs to tell really how, for what subject areas and how much is a child really in the regular classroom versus not in the regular ed. And I always think this section 11 is just a good area to summarize that so that it's clear to the parent and clear to staff who are implementing this, and also clear to a third-party reader like ODE or someone like me, an attorney who's working with a district. So this is just a good spot under LRE to indicate. An example might be that the child is in regular education except receives, pull-out services in a resource room for math support and reading support, or a student is in regular ed except for pull out for OT and speech. So whatever may be appropriate, but it's a good way to summarize it so it's clear how much is a student in regular ed and how much are they in some other situation like a resource room or pull out for related services, for example. Okay, on this state and district-wide testing, you have to fill out that page on the IEP and any individual accommodations in the administration of statewide or district-wide tests are indicated there. And you have to make sure that the accommodations for testing are allowable for those tests under the the test manuals that you're using, including the one for the state test. And then looking at if they're receiving an accommodation like additional time on a test for statewide or district-wide, they should have that same accommodation in the same subject areas on a day-to-day basis as an accommodation. So you need to make sure that accommodations you're providing on a day-to-day basis are there if you're going to provide the same accommodation for a state or district-wide test. And be sure and go back and forth and check that before you are finished with an IEP. And then this is where you decide about the alternate assessments. And there's now and has been for a couple years, the alternate assessment form that you have to fill out as part of the IEP process, looking at does a student meet the criteria for that. So be sure that you have filled that out, and students should not receive an alternate assessment unless they require that, which is typically looking at, do they have a modified curriculum in an area, or do they require accommodations that may be outside of the allowable accommodations for the state and district-wide testing. And there is no cap on the percentage of alternate assessments or numbers of kids that get them at the district level. However, this is an area that ODE looks at very closely. And so a district, if you anticipate that you will exceed 1% in your district of students on alternate assessments, you have to provide a justification to ODE. And the higher your percentage, if it's over 1%, the more likely you are to be monitored, or that will be looked at by ODE, including looking at those forms that you fill out as part of the IEP process to see if students meet the criteria and qualify. Okay, I want to talk about the signature pages, and then I'll stop for some questions. So the signature pages, the one page is 14, just the meeting participants, where everyone who participated in a meeting signs. And then the section 15 is what I call the parent signature page. So on section 14, meeting participants, be sure that, people get to the end of the IEP meeting, and, sometimes they've been long, sometimes they have been difficult, and sometimes people have to hurry up and leave early. For example, maybe a few minutes. Make sure that people are signing the participant page. And I would add that it's legible so that when you're printing it, someone can read the name and they know who it was and read what their position was, and then their signature. And then the date should be the IEP date unless they're not in attendance and they have provided some information, which maybe that was at a different time. And you need to make sure that the required people stay for the entire meeting unless they've been excused. And we'll talk about that in a couple of minutes. But everybody who is at the IEP needs to sign. Now, sometimes you may have a person, especially if it's someone who's not a required member, like there may be an OT at the meeting, but they aren't a required participant in the IEP, and we'll talk about that in a minute. But they may leave early. Maybe they talk about their part. They see if the parent has any questions or needs anything else related to OT, and the parent says no. So they may leave a little early, but what I typically do, not required, not in regulation, is for them to note the time that they have left on the IEP. But all the required people should stay there for the entire meeting, or you have not had a valid IEP meeting unless they have been excused. And we'll talk about that. So and sometimes the meeting was held face-to-face or video conference or telephone. Sometimes more than one should be checked, because especially since COVID, participants are participating in different ways at IEP meetings. I often participate when I need to virtually, Zoom, Google Meet, while some of the other participants may be, in a room meeting face-to-face. So there may be additional things that are checked there. I usually put, if it was face-to-face, but somebody participated by Zoom, either indicate, that one way was the primary way, or who participated in what way, or that also can go on a PR1. Parent signatures. This is section 15 of the IEP. And so with the parent signatures, again, you get to the end of the IEP meeting, people are anxious to leave. Maybe it's been long, maybe it's been difficult. And sometimes people race through this part too much, and it is filled out in an incomplete way, or it's not correct with what people intended. So you need to take a few minutes, and when you get to the end of the IEP, make sure the parent understands that based on how they want to sign the parent signature page, they're fully filling it out and signing, or that they are signing in the correct section. Because sometimes a parent, they may not understand it, especially if it's an initial, or they're hurrying too and check the wrong thing. So for example, if you want to change a student's placement after an initial IEP, the parent, if they don't sign that they are agreeing to that change in placement, then you can't change the placement, even if it's fine with them. So if they don't check the box and indicate that they are agreeing and consenting to the change in placement, then you can't do that. If they just sign, the part of this section that does not authorize a change in placement. And then you'll have to later get their signature if you really want to change that placement. So be sure and take a few minutes at the end of the IEP meeting, and just somebody be responsible to go through, make sure the whole IEP was filled out correctly. Because another area that's missed a lot is on the front cover page of the IEP. People forget, or they put the wrong date on there for when the meeting was, when is the next ETR due, when is the next IEP due? Sometimes the wrong year gets written, sometimes the wrong month or day. Just take a few minutes and make sure that the IEP is completely filled out. Everybody has signed, and then that the parent has signed as they wish to sign, but in the correct area for what they want to sign on the parent's signature area. Okay, I think I'll stop here and take any questions. Any questions, Steve?
No, I'm not seeing any right now.
Okay, I'm going to just real quickly go through the rest of the IEP form before we get to sort of like a sample. And then we'll get to some other information like IEP teams and excusing people. But I'm going to take a break after I get through the next IEP parts of just 5 minutes. Additional IEP content or program issues, which is section L in my handout on page 5. Just remember that at least a year before the child reaches the age of majority, which is 18 in Ohio. So we're talking about a year before that is age 17, that last page of the IEP is filled out correctly as to the transfer rights that will happen at age 18. And the school district or student can still invite the parents to the meeting. It doesn't mean they can't come anymore after the student's 18, but the rights and the student will function as parent for purposes of the IEP meeting and the signature as parent once they become 18. And unless there is a court order that has found them to be incompetent. So even if they are very low functioning as far as a disability, unless a court has determined them to be incompetent at age 18, they gain the rights. But a parent can be invited by the school district or by the student to attend the IEP meeting, but they no longer sign as parent. The signatures and a signature for consent then needs to come from the student. And even though the rights transfer at age 18, the district is required to provide any notices like invitations to IEPs, PR1s, any notices that are required to the parent, as well as then to the student who is 18 or older. And the reason for that is so that, parents then will still know what's going on, when are we having these meetings, what does the PR1 say, what happened, even if they weren't at the IEP meeting. So, it transfers at age 18 the rights to the student. ESY, somebody had asked questions about this, so let me talk about it. And then if you still have questions, we can address them. ESY, which is actually section 4 of the IEP, I really don't like where they have this listed so early in the IEP form. That's why I save it till the end to talk about it, because unless you have gone through the rest of the IEP, which, this is before the goals and objectives and the services, it is somewhat difficult unless a student has, typically needed ESY or clearly meets the criteria at the time you're having the meeting to tell whether the child will need extended school year services or not. So that's why it indicates, will the team need to collect further data and reconvene? Because a lot of times you do, because you just don't know at, early in the year, if that's when you're having an IEP meeting, if the student will need extended school year services or not. So if you need to reconvene, you can do that. You need to write the date by which, it's not the exact date you're going to reconvene, but the date really by which you will convene. Then you can do that, and that's appropriate to do. So it all depends on what information do you have about the student at the time you're having the IEP meeting? And is it enough to decide? Sometimes it is, because a child has needed ESY for, a number of years, for example, and based on the data you have, the child will regress and won't recoup that. And so they will need it. Now, remember, you can always change this later in the year if things would change. But if you don't have enough information, then you need to gather it to see if the student meets the criteria. One thing to think about, though, if you're meeting toward the end of the year, let's say in April, you should have a lot of data about the student by that time. And so I see a number of school districts who really have enough data in April, early May or something to make that determination, but they don't make it, and they indicate that they will reconvene, later in May, for example. Well, just remember that means you're going to have to either agree without a meeting, which we'll talk about, or you have to have another IEP meeting. So if you do have enough information, whenever you're meeting in the year, then, check the box, whatever way you would check, yes or no, they need it or don't need it. And then, and if you're checking no, just note if it's earlier in the year, you may need to reconvene if a parent requests that, or based on the data that you have by that time. So extended school year services are only provided if they are necessary, and note that word, to prevent significant regression of skills or knowledge, so as to seriously impede the child's progress. So it's based on progress. And then, or is ESY necessary to avoid something more than adequately recoupable regression? So all students typically regress over the summer, for example, but most students recoup that after they have come back to school in the fall. And if you look at the case law, what they typically look at for recouping is within a grading period, so about 9 weeks most of the time. But if a student can't recoup the skills they had, the level they had at the end of the school year, when they come back to school in a reasonable period, then and it will seriously impede their progress. So they're not making progress, which is how we decide if a child's receiving FAPE, basically. Then you would need to provide ESY, but not just because it's convenient for the parent. It would be good for the child. It would be helpful. It's if it is necessary to provide FAPE is the criteria for providing extended school year. So any questions about ESY or anything else up to this point? Steve, any questions?
No questions.
Oh, I'm sorry, I couldn't find my unmute button. Yeah, there's no questions right now.
Same thing happens to me once in a while. Get covered and I can't figure out how to find it. So I understand. Non-academic and extracurricular activities, which is section 9 on the IEP. The first question is, in what ways will the child have the opportunity to participate in non-academic extracurriculars? Typically, what is in there is that the student has an equal opportunity to participate as do regular education students. So what you're typically putting in there, unless there's some reason to put something else, is an equal opportunity to participate. So you typically would not be writing something in there like the child is going to participate in football. You would indicate that they have an equal opportunity to participate in any district-wide, activities or any extracurriculars that the student has. Because if you write in there that the student will participate in football, you're causing a problem for yourself because you put that in the IEP. And remember, things like football have tryouts and certain criteria that all students have to meet. So you don't want to write something in there that just says that a student just will participate. You want to just write a generic equal opportunity. And the second question, if the child will not participate in non-academic or extracurriculars, explain. Really, there's usually only something written in there if the child's at a separate facility, or so they aren't with students who are in regular education if it is a separate facility just for students with disabilities. So equal opportunity. And then the second question, typically only if the student is at a separate facility. Any questions up to this point? And then if there are no questions, I'm going to take a quick break. Any other questions on anything about the IEP form or sections?
I'm not seeing anything in the chat box.
Okay, I have, let's see, what time do you have there?
10:33.
Okay, let's come back in about 5 minutes. So that would be about 10:38 or so. So no later than that, about 5 minutes we'll come back.
Okay.
Okay, I have 10:38, so I think we'll start again. Maya will be on the next slide, which is related to team members. It starts. Yes, thank you. Any questions that came in while we're on the break? We're going to leave the IEP form itself for right now. So
Nothing came in on the break.
okay, thank you. Okay, I'm on page 5 of the handout, Roman numeral 6, so IEP teams. Okay, the required members, and note that other people can be there, but the people who need to be there and are required to be there are the parent has to be invited, obviously. Now, if the parent does not come, we can't make them come, but we have to offer them reasonable opportunities to come. So if you send them a proposed IEP date on the invitation, and remember, you need to use the invitation form, not just send an email that just says, oh, we're having a meeting on, Monday, November 15th at 2 at such and such building. You need to send the ODE required form invitation to the parent. Parent needs to be invited. If they indicate that they cannot attend at a particular date or time, you should offer them another date or time that they can attend. And the magic number, this is not in a regulation or anything, is 3. So you should give them, at least 3 opportunities that they are invited to attend a meeting. But if they don't come or say, I'm not coming at all, I don't want to come, then the district should go forward and have the IEP meeting without the parent, as long as they have been offered opportunities to come and you have documentation of that. Because you can't let the parent not coming to a meeting or that they won't attend hold up the development of IEPs on the required timeline. So you need to meet your annual review timeline. And if a parent doesn't come, you have it anyway without them. And the school district personnel need to sign as participants that they were there and developed the IEP. But you would put in a PR1 information about the opportunities that the parent had to attend, but they weren't there. Now, you can always have a subsequent meeting. So maybe, for example, a parent has some medical issue that they can't come, over a series of weeks, and you need to meet. You can explain to them that you need to meet and have an annual review, but you're willing to meet after that meeting with the parent whenever they can come. So there are other ways that you can get their input. And also remember that a parent doesn't have to be there in person. If they wish to attend by telephone or video now, Zoom, Google Meet, where everybody has that tech now to use. Don't forget about that. So if a parent says, I have to work, I can't come, there are other ways that you can offer them opportunities to come. Maybe they get a lunch break at work and they can attend. Maybe they can attend at a particular time, but if they have to travel to a location, then they can't. So, remember those other ways they can participate. Other required members, at least one regular education, note the language of the child, or if the child is not yet in special education, that if the child is going to be placed in special ed and have services, the regular education, if the regular education teacher, if the child's moving from grade to grade, then it can be somebody who they're going to have, or maybe both the regular ed teacher they had as well as somebody they're going to have the next year. So of the child, if they currently have somebody, and if they have more than one general ed teacher, then the district can designate who that will be. And it can be any regular ed teacher meets the requirement. But usually a district thinks about, well, who would make sense to be here? So if there is a area of the curriculum that child's having particular problems with, maybe math, for example, then it might be appropriate for the district to ask the general ed math teacher to come. But if they can't, it's okay if another general ed teacher is designated to come. At least one special education teacher, or where appropriate, a provider. So for example, if the child is only identified to receive speech services, but there isn't anything else they need, then the speech provider could come as the, instead of a special ed teacher if the child doesn't have one. But otherwise, the intervention specialist would need to be there. If there's more than one, the district can designate which one comes. And that's where I meant to say that if the child has an initial meeting, they're not yet in special education services yet, then the IS who would be providing services, if the IEP is going to include special ed services, can come as the special education teacher, but otherwise it needs to be the special ed teacher of the child. And then the school district rep, the district rep has to meet certain qualifications. They either have to be qualified to provide the services or supervise, so an administrator, in order to serve as a district rep. They're to be knowledgeable about the general curriculum. They're to be knowledgeable about the availability of resources, and not in the regulation, but they need to be designated by the school district and authorized to make decisions at the IEP meeting. Because it is inappropriate, for example, to say at an IEP meeting, oh, I'll have to go ask the superintendent about that. You know, I don't know if we can do that or not. The district rep needs to make a decision at the IEP meeting and be authorized to do that. Now, if the superintendent needs to participate in that, then either they can come to the meeting, the IEP meeting, and function as the district rep, or they're the highest, ranking administrator, so to speak there. Or things that you can do instead of saying, well, I can't decide that, I have to talk to the superintendent, is sometimes something comes up in an IEP meeting where you, out of the blue, you're not expecting, and you don't have enough data to really decide. An example might be a request from a parent for a residential placement. It is okay to say, well, I need to go and get more information about that and find out about the placement you're requesting. So let's schedule another meeting for a later date. And if you're running up against an annual review date, then you can propose what you think is appropriate at that time at the meeting, which may be, if you're getting a question about residential, to remain in the district, but say, after we gather this additional information, we'll come back and meet again and make a decision about that. So you can have, more than one meeting if you want, if you need to get information, but that's different than saying, I have to ask the superintendent if it's okay. So the district rep needs to be authorized to make decisions at the IEP meeting, which can be, we need to have another meeting, but don't miss your annual review dates. And then you need to have an individual who can interpret the instructional implications of the evaluation, who can be another member of the IEP team. So whenever you have had an initial evaluation or a re-eval, typically the school psych would be there, unless there's someone else who can explain that evaluation data. If you're talking about OT or speech, typically the related services person who can explain the evaluation data will be invited to the meeting. Now, note, they're not a required member to be at every meeting, but if they're not there and there are questions about evaluation results, then somebody else should be knowledgeable enough to be able to talk about, the evaluations in those areas. At the discretion of the parent or school district, other individuals who have knowledge or special expertise regarding a child can be invited. So the school district can invite others it wishes to invite to the IEP meeting, as can the parent. And it is really up to the school district as to whether they believe the person they want to invite has knowledge or special expertise to come to the meeting. Same with the parent. If the parent wants to have the grandmother come because they think they have information about the child that would be helpful, they can invite them. So basically, parents as well as school districts can invite who they would like to the IEP meeting, and it is fine for that person to come. And then whenever appropriate, the child, which when transition services are being discussed, they are always to be invited. So that means at age 14 and after, they are to be invited. And you need to put that on the invitation that you're sending for the meeting. So you have documentation that it's really up to the parent and the child, whether the child actually attends or not. Sometimes, it's not appropriate in the parent's view for the child to attend, and that's okay, but they need to be invited to the meeting and have that opportunity. It typically would be there once they are 14 or older. And if there are parts of an IEP meeting that it may not be appropriate for a child to be there because there's a discussion that the parent wants to have with the district at the IEP, it's okay to have the child there for part of the meeting and then they can leave. But remember, once they are 18 or older, they function as the parent for the meeting and sign as parents. So they do need to be there for that reason also, including, for the meeting. Now, if the child, when they're 18, just like a parent doesn't have to attend and we can't make them, if they decide not to attend, then, they don't have to come. We can't force them. We need to give them the opportunity. But then the person functioning as the parent is not at the meeting once they are 18 or older, although the parent can come as another member of the IEP team as a participant. Before I go to amendments to IEPs, any questions about team members? And when the team members do need to stay there for the entire meeting, and you don't have a valid IEP meeting if the required members leave. So people who aren't required to be there can leave. So for example, if you have 2 Gen Ed teachers there, one is okay to leave, but one needs to stay for the entire meeting. And I know I've been in a number of meetings where principals are a good example. They have something come up and all of a sudden they get up and leave the meeting. Well, if they have an emergency, of course, if you have to leave, you need to leave, but that's not a valid meeting then. You might have to have another one to have all the members that are required to be there for the entire meeting. But if they have to get up and, go out to take care of something for 1 minute or 2 minutes, it's an emergency, that's fine. But they can't leave and then not come back or be gone for, a significant portion of the meeting. They are to be there for the entire meeting. So any questions about IEP teams and the composition?
Yes, there's a question. Does the parent absence affect the initial IEP implementation?
Not for the meeting. If the parent has been provided opportunities to attend in more than one, and they just won't come or don't come, they don't have to be at the meeting itself. The district can proceed without them, needs to sign the district personnel as participants. However, for an initial IEP, you do need the written consent of the parent to implement the IEP, but they don't have to be at the IEP meeting in order to give that consent. So other questions?
Yeah. You mentioned earlier that a teacher could leave early if excused. Can you address that?
Yeah, I'm going to get to that in a couple minutes. So whoever asks that question, just wait till I get to that portion of the presentation.
One person says, just want to confirm parents are not required team members. If you have made attempts to get them to participate, you can hold the meeting without them.
That's correct. If you have given them reasonable opportunities and more than one, the magic number that ODE looks at is 3, and they just don't come, then yes, the district can proceed without them. And in fact, if it is an annual review date coming up, you need to proceed or else you're out of compliance with those dates. So, don't let parents, sometimes parents think they don't want to have an IEP meeting for some reason because they may think that something's going to change in the IEP that they don't want to change. They can't hold up the process just by never attending, but you need to give them a reasonable opportunity to attend and participate. Other questions?
Yeah, and just to follow up on that, our recent guidance from ODE, and this is as a result of a formal complaint that was filed, is that they need to give multiple attempts and multiple dates and multiple times, not just sending home one invitation that says, we are holding this IEP meeting on November 11th at 9 o'clock and sending that 3 times, but saying, if they don't respond to the first one or say that date doesn't work, then you propose another date and another mutually agreed upon time is specifically the language that ODE has written in finding letters and complaints. So as you send those invitations out, just consider that you're allowing multiple options, modalities, and ways to attend the meeting to the parent to allow them that opportunity to participate.
Yes, thank you. Absolutely agree. And as I mentioned before, if a parent just didn't come, but you've offered them the opportunities, you can always have another IEP meeting later. Just don't hold up developing it and proposing the new one. So you have met your dates that you have to have an annual review, but you can always have another meeting, a month or 2 later, if that's what the parent would like to do. But that's not your annual review. That's a meeting in between a meeting. So thank you. Good comment. Other questions?
Yes. For students that are homebound due to medical needs, would a gen ed teacher from the grade level need to be in attendance even though the student does not have time with that teacher at all?
If a student does not have a general education teacher for anything, and that includes remote, if they have a remote gen ed teacher, then that would be the gen ed teacher. But if they don't have one, then if I would say yes, because at an IEP meeting, every one of them, you're always asking the question, how much will the child be in special education services that do not have regular ed students with them and only have an IS, for example? And how much of the time or what subjects will they be in general education? You're answering that question every time you have an IEP meeting. So my concern is even if they don't currently have a gen ed teacher, but you don't have one of that grade level that they would have at the meeting, then you could be alleged to be predetermining what the placement and what the services and who are they received from.
Yeah,
So
and the guidance we give too is around the fact that obviously, the end of, the end goal for all students would be inclusion to the greatest extent possible. And that if that does ever, that with that continuum, including general education, classroom and setting, then that should certainly be a consideration that's made, as well as what Susan said about predetermination. If that teacher is not in that conversation, then it could be presumed that you're predetermining that the student will never interact in that general education setting. And that's certainly not something that ODE would shine good light on if it gets to that point. So,
right. It always has to be something that you're looking at, even if it's decided that a student is not going to be in any gen ed. So yes, I agree. Other questions?
If an intervention specialist is dual licensed, can they fulfill both roles?
No, they can't be at a meeting as one person who's meeting both roles? So the answer to that is no, because look at the language of the regulation. It says special education teacher of the child and general education teacher of the child. So you're going to have two teachers there, because typically an IS of the child who's working with and teaching the child is not going to be actually providing any general education to the child. They're typically not going to be working as an IS providing special ed services, and then at the same time be off teaching, a science regular ed class. So typically you will need to have both people there, and one person cannot meet both of those functions. Okay, other
That's all.
questions?
Nope, that's all I'm seeing right now.
Okay, I'm on the handout on page 6, amendments to IEPs. You can do amendments to IEPs in between annual reviews, and those don't have to be, typically you would not be going through the entire IEP at an annual review. You're there, at meeting in between annual reviews. Typically you are at a meeting in between an annual review because either something might need to be changed on the IEP, there's a concern that has come up about a child, something needs to be added. So you can focus on the reason for having the IEP meeting in between annual reviews. It doesn't substitute for an annual review. You still have your annual review dates. There are two ways to amend an IEP. You can have an actual full IEP meeting that meets all the requirements with all the required people there for the entire meeting, or the school district and the parent can agree to amend an IEP without a meeting. And that has to be an agreement. So if there's any disagreement about that, then you need to have a meeting with everyone required to be there at the meeting. But if you can agree on a change that's being made, for example, maybe a child has a particular goal and they met that goal. And so maybe the parent and the district outside of an IEP meeting can say, oh, let's make this goal more difficult, or move on, or add it. Or if the child's not doing well with it, maybe we want to make the criteria a little different or have a different goal. Maybe we found that it's not appropriate for the child at this time. If you can agree on what to change, then you can agree to, the exact language of what needs to be written in as an amendment. You indicate that there's a section on the front page of the IEP, the cover sheet at the bottom. And usually you need more room than that, which most of your electronic systems allow you more room, but you write down exactly what the amendment is. And then either you need to write exactly the language of what you're adding or changing or deleting, or you can put the section that you're changing and then within the body of the IEP, make that change. But just make sure that that is absolutely clear to everyone, the parent as well as district personnel, what that amendment has been. And then the school district and the parent have to agree on that. And you need to indicate agreement by the different ways I see is people signing or initialing on the amendment section at the bottom of the cover page of the IEP, or depending on what it is and how extensive, you can also have another signature page, especially if you have had an IEP meeting to make the change that indicates that there was, an IEP meeting to make an amendment on such and such a date, and then do a new participant page, because that's a good way to show that everyone that needed to be there was there, and that you have documentation of that through signatures, and it's clear what happened on what date. So when there is a meeting, at least I typically would have another signature page done, and I would have that attached either to a new IEP with the amendment, or just attach it as a second signature page if the amendment has been really minor. So somehow you need to indicate who approved this. And if you initial because there was no meeting and you do that on the bottom of the signature page, really it's only the parent as well as the representative of the district who's authorized that needs to initial or sign that. But typically what I see is districts often have the required members of the IEP team do that, even if there has been no meeting. So, but somehow you have to indicate that this was approved by everyone, but you can do it in between meetings. I'll stop there because, and then I'll go on to excusal. Any questions on amendments to IEPs?
So were you saying that if we do an amendment, all parties don't have to be there? It just has to be a representative of the district, so the IS or a district rep and a parent? We don't have to call the whole IEP team?
Well, you have to look at how are you amending? Because remember, you can amend by having an IEP team meeting. And if you're doing it that way, then yes, all the required people have to be there. So you need to have everyone there that's required to be at any IEP meeting. But you also can amend by agreement without having an IEP team meeting. And so if you're agreeing to amend the IEP in between annual reviews, because you always have to have those, if you're agreeing to amend the IEP without a meeting, then in my view, now remember, always check with your own legal counsel because I'm not giving you legal advice on this and I'm not sure what ODE says, but the way the regulation reads, it's just the district and the parent that have to agree. So if you're doing an agreement without an IEP meeting, then my view is that only the designated person from the district who can agree to make that amendment, which is typically an administrator or district rep, and the parent need to sign or agree. But I see a lot of districts that have all the required members of an IEP team meeting who would be required to be there, initial or sign the amendment section on the cover page. So I think that you can have an administrator and parent just authorize it in between IEP meetings if you're not in between annual reviews, if you're not having an IEP team meeting. If you're having a meeting, then you have to have all participants there. And then, you know, everybody would need to sign as a participant. Steve, do you have anything that you've heard from ODE on that about when you're not having a meeting to amend the IEP, who all has to sign or authorize that?
Yeah, the only thing we've heard really is that when amending for like pretty significant things like a change of placement, obviously the team must get together and discuss that. But like little things like, you know, if there's just like a maybe they're changing the grade level for a reading goal or something like that as it's written in the original IEP, then just simply informing the parent of that, documenting it in a PR01 that the parent was, you know, contacted via phone to let them know that the goal was being amended for whatever reason. It's mostly around the big like change of placement, removal, addition or removing services, things like that, that we've seen districts and guidance be that the whole team should be involved in that conversation.
Okay, any other questions on amendments?
Always, I don't, it's not a question necessarily, but always follow up those amendments with PR01s. You know, if one person in the district is then signing, initialing or whatever, saying that they made the amendment, also indicate in the PR01 that who it was discussed with, who else had input on that decision, just to cover on the back end in case it does get to the point where you're being challenged that maybe a unilateral decision was made and the team wasn't involved. So just the importance of that PRO1 can't be stressed enough.
Yes, I agree. So PR1s after amendments, just like after any IEP meeting. So thank you. Okay, let's move on. Bottom page 6, excusal for required members of the meeting. There is an optional form for this. And there's a difference here as to whether someone is a required member or not. That's the main thing you have to determine. A required member of an IEP team needs to be excused if they're not going to be attending, or they're required to be there for the entire time, and they are not going to be attending for all of the meeting. So there is a form for that. It's an optional form 5, although a district can have their own. And the related services people are not required members, although there are arguments, maybe under certain circumstances they are. But the way that I read the regulation from the federal, what's called the federal commentary to the federal regs, I would read that related services people are not required members. And again, you can check with your own legal counsel on that. So they don't need to be excused because they're not required to be there. So they don't need an excusal. It's up to the district whether they are to be there or not. And the parent and district do have to agree on this in writing if they're going to be excused. The parent needs to sign that they agree to that. And so really and I would say the district rep needs to be there. So the district rep should not be excused. That, it's hard to look at the regulations and say that for sure, but it's just a bad idea. Because if the district rep is not there, there are so many problems can come out of that I read them as a required member who is not to be excused. So really, we're just talking about the teachers, like the IS or the gen ed teacher to be excused. And if you have more than one general education teacher or more than one IS who typically is at a meeting, then you only need one to stay. So if you have 2 gen ed teachers, and one has to leave or isn't going to be there, but they often attend, they don't have to be excused as long as one is still there for the entire meeting. The one who needs to be there, or the only one who was going to be there, then would need to be excused. And if the parent won't excuse them, they're not excused. And they have to, if they are having information related to their subject area or area that they work with the child on that is going to be discussed at the IEP meeting, then they have to submit in writing, and note the in writing, information to the parent prior to, and that does not mean that they get it right when they're walking into the IEP meeting. It means prior to, so all members of the IEP team, including the parent, can review that information. And if they submit the information, such as the progress or any concerns in the area that they're responsible for the child, then they have to do that. And then the parent needs to agree and consent to that by signing, and then they can be excused. There may be reasons that you need to excuse people that come up. It should not be the typical thing you do. It should be by far an exception to the rule to have somebody excused. But an example might be maybe somebody gets sick, or you need to have a meeting, but they're going to have surgery or something, so they have to be out. That may be an appropriate reason, if the parent's agreeable, to be able to excuse somebody. And sometimes, that comes up sort of the last minute, but they are to provide in writing that information that they have that's related to their area of responsibility. Any question, and school districts should monitor that, as I said, and it should not be the rule that, one particular teacher, for example, always wants to be excused. The expectation should be that they are there. And just when you have to have an excusal for some reason, you do that. It may be that a parent doesn't get along with a teacher. And so maybe it's better for everybody, including the parent thinks so as well as the district, that somebody be excused from a meeting. So any questions about excusals? Okay, hearing none.
There is one that just came in right when you said
Okay.
that. What if they are not a required member, but they were on the invite? Does the excusal form need to be completed?
It's not an excusal, but you would probably issue a new invitation to the parent that deletes that person from the list, and maybe somehow, tell the parent why you're doing that. Because if they're not required, it's up to the school district whether they attend or not up to the parent. But the invitation is to indicate accurately who's going to be attending. And so if somebody's on the invitation, but not going to attend, then I would say you ought to issue a new invitation and then, know what's different on it that you're changing, because the parent may be expecting to discuss something with that person, for example, or be somebody that likes to have everybody there. It's not up to them, but they should have notice of that. Now, sometimes you won't be able to, like an emergency medical problem or something like that. And then, you can't do it. You would explain to the parent and then maybe put in the PR1 why everybody that was on the invitation wasn't there. But you should have the invitation be accurate. Other questions?
Yeah, I think just to clarify, I think the question is like, usually the person said that usually this happens the day of or last minute due to student issues. And our guidance has always been like, if the person's written on that invitation that the parent has signed, then that is them giving consent essentially to those people participating. So if that person is not participating, to still fill out that excusal form and once again mark that in the PRO1, just because on the surface it looks as if the parent or that person wasn't in attendance that was originally agreed upon with the parent.
I think that's another way to do it. And if that's the way ODE is preferring it, you could do that. But I would just say that if they're not a required member to be at a meeting, then they don't have to be, so we don't need them to be excused. So, but it's another way, I think, to take care of that. Somehow we have to match up documentation with who's actually going to be there. And so the parent has notice of that. So I think that would be an alternate way. Any other questions about excusal? Okay.
Yeah, the only other question we get regularly, and I don't know if you want to expand on that, is what the definition of what prior to the meeting means.
Well, to me, the purpose of providing information prior to the meeting is so that the rest of the IEP team, including a parent, has a chance to think about and look at the information that that team member who's not going to be there is providing. And if you hand it to the parent when you walk into the meeting, that really doesn't provide that. And it certainly, if they're walking into the meeting, to me, that really doesn't make sense as prior to. But you might send them an email, for example. Maybe you send the information home somehow the day before. So there are different ways you can do it. But at least in my mind, it's hard to say that prior to the meeting equals hand it to them when they're walking in. Maybe you send it to them in the morning of a meeting. If the meeting isn't to the afternoon. But yeah, we don't have definitions of those things. But I hate to say common sense sometimes in special ed, but I think it's a little common sense as to what makes sense as prior to the meeting so someone can read the information and think about it. Any other questions?
Nope, not right now.
Okay, I'm going to quickly go through some of this because there is an example I just want to quickly go through that's in the materials. This is the next slide on consent issues. Parents can withdraw consent for special education, but they have the right to do that, but it's an all or none. They withdraw consent for implementation of all special ed and related services, or, it is dictated by the IEP. It's all or nothing. And there are special requirements for a PR1 if that is done. And there is a requirement for initial implementation of the IEP. The parent has to give consent. And there has to be consent in Ohio for a change in placement for the child. Prior written notice, which is section 8. I'll just mention, and we've said it several times, those are important. They have to be well done and filled out well and accurately, answering all the questions. And I think at one of the subsequent sessions of the ESELA sessions is going to cover PR1s. Decision-making in section 9. If the parent and the school district don't agree is where this comes up. The district makes the final decision. The parent has to have input into discussion of the IEP and what is being proposed. But except for the areas that the parent has to give consent, basically change of placement and the initial IEP, it's the district that makes the decision in the end as to what goes into the IEP. We do not, if we don't need the parent's consent, like to add a new goal or objective, because that's not a change in placement, then the district can go forward with implementing the IEP without the parent signature as agreeing when we don't need consent, as long as it provides a PR1 that indicates the district's moving forward with implementation and before we actually implement. If there's a split of opinion between the parent and the district, it's not a vote. You don't vote, and whoever has the most votes wins on what the IEP is or what's going to be implemented. It is the district rep that makes the final decision. And the parent cannot hold up implementation of anything other than when they have to consent, the initial IEP or a change in placement. Otherwise, as long as the PR1 is used to provide notice before the implementation, the district can move forward. I just put a couple court cases there related to provision of FAPE, and that have indicated that, the big questions are to see if districts have done what they're required to do. Were the requirements of the statute and the regulations, both at the federal level and state, followed? Is the IEP reasonably calculated to provide some educational benefit? And the key is progress. Do we have documentation of progress to be able to show that we provided FAPE? And last thing I'll mention here, it's almost never too late to correct mistakes. If you find there's a mistake on either an evaluation form or an IEP, hold another meeting and fix it, because it will just become compounded if there's a mistake or an error or something that hasn't been addressed, and you don't change that until you have the next IEP or in 3 years an ETR. So you do, hold a meeting. If there was a mistake, there was one, but it's better to fix it than not do that. Okay, with that, I'm going to go quickly, because we only have a few minutes, through just a sample case, and this is in the slides, and I am going to go quickly through it. And so Maya, these are the next series of slides. We'll go quickly through them, and it starts with IEPs applying your skills. Okay, there are errors in the next slides, and so please do not provide these to somebody else or a colleague of yours and they think that the slides have all the correct things on. This is a spotting your errors exercise in part. So there are mistakes in the slides because that's what I want to talk about. Okay, next slide. Here is just a quick description of a child, a fifth grader, that talks about the child's characteristics. So I'll just let all of you read that yourself quickly. Okay, next slide. We're now halfway through the next year and you're about to write an IEP. All of his prior teachers the child had are no longer there. What paperwork would be helpful to you? Just think about that for a minute. Nobody at the IEP meeting is going to know this child. What paperwork would it be helpful to have? Things like progress reports, evaluation team reports, district statewide tests, work samples may be an example of what might be helpful for the team to gather, because nobody there will know this child hasn't had them before. Okay, next slide. Okay, this is a sample of IEP and ETR timelines. And there's an error in this, so please see if you can spot the error. I'll tell you what it is in a moment. Okay, the error on this is about IEP effective dates. The last line on the slide says next IEP review, January 23rd. And it says in 2022 as an example. Well, that's wrong, because if you trace back to, you look at the ETR, then the IEP effective date should have been within 30 days, let's say it's an initial IEP, of that ETR completion date. So that date was wrong. It should have been approximately January 12th or whatever 30 days were. And then on that prior IEP, it had the wrong dates. So the current IEP that's being written picked up those wrong dates. And so to just say ending on January 23rd, that's not correct. And I would also add that it says January 23rd, where even if you were using these dates, it's January 22nd. So one day before the 1 year annual review. And I'm assuming that's the exact number of days in a year. I didn't count them out on this. So it's that it didn't trace out quite right, meeting all the requirements. Okay, over on the next slide. Again, quickly look at this and what are the errors, or at least arguable errors on this slide. Looking at the description of the child that was in the first slide you had. Okay, well, one error is that it's checked no for behavior. I think somebody asked a question about this, that this child does have behavior issues. When you look at the characteristics, that should be yes. And then down where it says, does the child need assistive technology devices or services? It says no, but arguably it could be yes. You would need more details about the child, but the child may need them from the description for some reading, writing, or organizational issues. So that could be a yes, depending on more detail about that area. Okay, next slide. Present level of academic achievement and functional performance. This is really for a present level. This is too vague, because it just says the child struggles with reading and often requires assistance. Need to be more specific. For example, what areas of reading, 5 basic areas: phonics, phonemic awareness, vocabulary, comprehension, fluency. Need to be more specific about what are the areas in which this child has difficulties. There's no baseline there. There's no baseline quantitative measure in which to compare to progress on the goals and objectives that you can determine if progress is being made. So you need something quantitative there and more specific about what the concern is. Okay, over on the next slide. The measurable annual goal that's in this student's IEP is Bobby will read passages at a 4.0 grade equivalency level. Just think about, is this measurable or not? Or, do you need more information? A goal like this should be more specific, because what are you asking a child to do? Remember when we talked about what do you need in an annual goal? Are we asking the child to read silently to themselves out loud? And how to know if the child's reading effectively if it's silent? How are we going to measure? What are we going to use besides just 4.0 grade equivalency to see if the child is making progress? Now, sometimes it can be, appropriate in a goal to have something like a 4.0 grade equivalency as the measure, as long as then whatever you're using to measure that also gives an apples to apples, oranges to oranges grade equivalency level in the specific area of reading that you are measuring. So that's up to the IEP team, but just make sure it's specific enough. And in the present level, you have information you can use to compare. Over on the next slide, the methods on the IEP for determining progress and measuring for this student are observation and anecdotal records. I will just say that if it is curriculum-based assessment, it's probably better to have the actual assessments or to have, short-term cycle assessments or something about an actual assessment you're using, not just observation and anecdotal records. That is hard to say that that's accurate. So it's better for you to have some sort of assessment and a quantitative measure that comes out of that. Frequency for reporting every 9 weeks, for example, in the written report. And then over on the next slide. This, I'm not going to talk about this. We already talked about for non-academic and extracurriculars, what is, I would at least recommend go in there typically. Over on the next slide. And I'm not going to read these to you. I'll just let you read the next two, which has the IEP team considered things. This is on the IEP. You have to check this off on the IEP form, but you need to make sure you've done that. And then the next slide talks about LRE. We have already talked about that. I will skip that slide. And then now the last couple of slides. These are suggestions, just, don't forget these things. I will not read them. You can just read them to yourself. And so that is the slide that talks, don't leave boxes blank. And then on the next one, connect them all for FAPE. Okay, with that, so we have time for questions because it's 11:30. I can stay here for a little while if anybody has any questions, since we're here at the end of time, but this is really the end of the presentation. So if you need to go, it's 11:30, feel free to do that. And Steve, I'll stay for any additional questions and anyone can stay, but do you have anything that you just wanted to say in case some people have to leave?
No, I don't have anything other than following up with the survey that was provided in your original link about the session. Our next session is on December 9th, same time, same link, and that will be discussing 504s. If you have any follow-up questions or support that comes that's needed after the conclusion of today, feel free to reach out to your district special education consultant. If you're not clear on who that is, go ahead and send me an email. And if it's not me, I'll make sure to get you to the right spot. But We also want to thank Susan for her time today and discussion and information, as well as Maya, who was kind of working on our back end logistics with the slideshow and everything like that.
Yeah, thank you, Maya. I appreciate it too.
Yeah, I'd also like to thank the sign language interpreters that provided those services today for us as well.
And I will stay. So Steve, if there are any other questions that have come in or anything anybody has on anything about IEPs, that's fine.
I'm not seeing anything in the chat box. So what I'm going to do is I'm going to end the recording for now. And then if there's questions, obviously we'll be here to take those.
Okay, I'll stay on just for another minute or so.